Gomez.
Good morning and welcome to the fourth and last day of the Norman Manley Law School Legal Aid Fair. Today, we're having Reverend Norman Mills, who will open in prayer with us. I'm Janet Levy, and I will be your moderator for the day. Welcome, Reverend Norman Mills, who is also an attorney at law and the associate pastor of the Bethel Baptist Church. Welcome, Reverend Mills.
Thanks. Let us pray. O Lord God, eternal and true, we acknowledge you, the God of justice and mercy. We give you thanks for the opportunity to contribute to the common good by our participation in the purposes and objectives of institutions established for the administration of justice, the protection and enforcement of legal rights, and provision of legal services for all, regardless of status. We give thanks for legal aid that endeavors to ensure that no one is denied or excluded from reasonable access to the services of lawyers and the courts. We give thanks especially for Norman Manley Law School Legal Aid Clinic and for its work and achievements over the years, for its principals, directors, administrators, attorneys and tutors, paralegals, secretaries, student attorneys, and ancillary employees. All praise and thanks to you, O God, for seeing the Legal Aid Clinic to this day of celebration and review, a day of gratitude for the opportunity to have served the community throughout the years. O Lord God, our help is in your name alone. And so now we entrust the day's proceedings to your enabling and blessing, and in all things, may our undertakings diffuse your praise and glory in the world. Faithful God, enabler, savior, and guide. Amen.
Amen. Thank you, Reverend Mills. We now turn over to Ms. Toni Morris, who is a second-year law student, and she will provide a review of the week's activities so far. Thank you, Ms. Morris.
Thank you, Ms. Levy. Good morning, everyone. This is a review of the week's activities. On January 9th, the first topic was stop and search. Should you allow the police to search your vehicle? And what are your rights when stopped? The second presentation was changes to the Road Traffic Act, what a driver should know, and the matter of unpaid traffic tickets. The first topic was done by Mr. Bert Samuels and the second by Dr. Garth Little. On January 10, the first topic was Dem no Call Up Him case, the right to counsel and the role of duty of counsel. This was done by Mr. Hugh Wilson. On January 11th, the topic was New Year, New Look, expungement of criminal records and what goes into creating a criminal record and cleaning up your criminal record. This was done by Detective Sergeant Leston Ferguson. The second topic was just a little split. The possession of marijuana, is it still legal and how much is legal? This was done by Mr. Robert Fletcher. And closing on the 11th was bad sex, looking at offenses under the Sexual Offenses Act. This was presented by Mr. Jeremy Taylor, KC. Today, January the 12th, the first topic was summer case done. What happens if your matter is adjourned sine die? This was done by Ms. Dion Cruikshank. Later today, there will be Unfit to Plead, assisting the mentally unfit prisoner, the options and recourse. This will be presented by Ms. Tamika Harris. And closing out the day is Ms. Tanisha Powell, presenting silent pleas, domestic violence, and bad touch, good touch, childcare and protection. Thank you.
Thank you, Ms. Morris. So as you can see, we have had a full week of activities and we continue today. Persons are here. We invite Ms. Kalena McKnight, second year law student as well, to give us a review of the work being done at the legal aid clinic. Ms. McKnight?
I'll be going through the work of the Legal Aid Clinic. The Legal Aid Clinic is the practical training arm of the Council of the Legal Education's Norman Manley Law School. The principal objectives of the clinic are to provide practical clinical legal training to students using real client files, to develop in students a sense of professional responsibility, social justice, and volunteerism, to provide students with the skills and competencies necessary to enable them to produce quality legal work in a real-world environment, to provide access to justice to poor members of the public. The clinic accepts litigation cases for matters within the jurisdiction of Kingston St. Andrew. Notwithstanding the generality of this provision, an attorney who so desires, and upon the approval of the director, may also accept litigation matters for jurisdictions outside of these geographical locations. The client, in general, the legal aid clinic will not assist the client in the following circumstances where the client has already had retained an attorney and this retainer has not been terminated, where the client has terminated his attorney's retainer for non-pecuniary reasons, when the matter has already commenced before the court and is part heard, or a substantive hearing is imminent. The acceptance of a case would result in the clinic surpassing the number needed for the efficient instruction of students. An attorney may exercise a discretion in the following circumstances: the likelihood of success, the belief that the case will enhance the students' learning in their legal education. There are issues of potential law reform or development of the law for any other reason prescribed under the Legal Professions Act and the canons. The clinic is open to the public from Monday to Friday, Monday to Thursday from 9 a.m. to 4:30 p.m. and on Fridays from 9 a.m. to 3 p.m. Thank you.
Thank you, Ms. McKnight. So as Ms. McKnight would have indicated, we have at the clinic, we provide services to the general public as well as we provide practical experience for the students at the law school. As was mentioned today, we're having several agencies and several activities are going on the outside. And we do have a little preview of those events and the different agencies. And I now turn over to Ms. Tamika Carter, who will take us through a review of what is happening on the outside. may see that we are not quite ready for Ms. Carter. I will get some more information on that shortly for you. So just a little bit more about the Legal Aid Clinic. We offer services as well to persons who just need to consult, not necessarily need to litigate. We do divorce matters, criminal matters, land matters. And in fact, today we have National Land Agency who is on the outside. We do have the OUR, the Registrar General's Department. So if it is that you have an interest or anything that deals with births and deaths, that's the department that will be of assistance to you. We at the clinic feel that students should have a comprehensive, as much as possible experience with the different agencies. And as a result, we had invited several agencies to participate in this event. Ms. Carter, are you ready for us?
So good morning, everyone. So we're here at the Legal Aid Fair and we have a couple sponsors here today. So one of our sponsors here today is the Ministry of Transport and Mining, and they're the Road Safety Unit. We also have over here, we have our registration desk, and this is where the Council of Legal Education, the Norman Manley Law School, will be. We also have Bridge 99 FM here with us today, and they will be having media coverage going with us throughout the day. And if you come with me a little bit closer, we have other sponsors that are here with us today. If you come over here, we have the Registrar General's Department, and they will be dealing with all the matters that relate to birth certificates or anything else relating to the RGE. We also have the Office of the Children's Advocate here with us today, so that they can give you all the information needed on children. We also have the Administrator General's Department that is here with us, and they will be helping you with the information in that regard. We also have the Justice here with us today, so they will give you all the information on any information that we need in relation to the system that we have. Many other sponsors that are here that include Indicom, the Office of Offender, the Office of Utilities Regulations, and also the Ministry of Labor here, that is the NIS division, and also the resource organ, as well as NLA, that is the National Land Agency, and the Office of the Department Prosecutors, that is the DPP, as well as Ministry of National Security and the Dispute Resolution. So as you know, we have so many sponsors here with us today, and also learn so much.
Okay, thank you, Ms. Carter. We did have some technical issues, and just to Repeat, we have National Land Agency, OUR, Registrar General Department, the NIS Office, Legal Aid Council, Jamaica for Justice. We have the Justice Bus that deals with restorative justice. We have LAMP, we have Ministry of Transport and the Ministry of Labor. So there are many opportunities here for you to come on down and speak with different agents of these departments, have your questions answered in terms of any issues that you're having with any of these entities. So we invite you to come on down to our Legal Aid Fair, 18 Gibraltar Hall Road, Mona campus. Today, we are having a part of the Legal Aid Fair. We do have the celebration, or part of the celebration of our 50th anniversary of the Nomamanda Law School. And today we do have our representative for the year class of 1987, and that would be Mr. Lance Hilton. We do have a presentation by Mr. Hilton, and we would invite again Ms. Carter to oversee that proceedings. Are we ready, Ms. Carter?
And I'm looking forward to this
Hi,
one.
Miss Levy. I am
It's going to
here.
be a special because as a part of the Council of Legal Education's 50
I'm
weeks
not
to 50
hearing
years
as well
celebration,
because we have a
they
lot
have
of
been
noise that is
honoring
going around
graduates of
us.
this fine
But
institution.
we are
One
here
such
on
graduate
site
sadly
at the Legal
passed
Aid
last year. Her
Expo,
name is
Legal Aid
Miss
Fair
Nancy
Expo,
Anderson,
and we
OD.
are waiting
And
on
to
Mr.
commemorate
Hilton to
the
do the
opening
release
of
of
the
the
Legal Aid Fair,
balloons for
they
the
will be
Legal
releasing
Aid
some balloons.
Clinic
And
for the
you'll
opening.
notice when we turn the camera to the balloons, you're going to see one black balloon honoring Miss Nancy Anderson. So it's a fantastic vibe, Rich Nation.
So we have
I'm
our
enjoying what's
balloon
happening
release
so far.
that is
I'm
supposed to
looking forward to
happen,
learning a lot.
and
I
this
don't know what Rich Nation
is
has to write.
for
the
celebration of our 50 weeks to 50-year celebration that we have honoring graduates of our school. One such graduate includes the late Miss Nancy Anderson, who has passed last year. To commemorate the opening of, we invite this week's honoree, Mr. Lance Hilton, representing the class of 1987, to mark the official opening of the Legal Aid Fair 2020 by releasing the balloons. So we are just waiting for Mr. Hilton to release these balloons that we have to commemorate the opening of the Legal.
Last Hilton, representing the best class of 1987. That's right. That's right. I was there. I was there. I remember you. Yeah, I remember we shared the
So we have Mr. Hilton here to release the balloons commemorating the Legal Aid Fair.
Black balloon will be honoring the late Miss Nancy Anderson, OG, who passed last year.
Elements are excited at the opening and the grand fair. Everybody's excited. That's part of the whole plan. The elements are excited at what's happening here.
Yeah, once later they will be in the body class. Right? Let's wait for the team to get everything together. Very beautiful day. So people coming in. Come on in, people. You know, don't be shy. I'm not going to be a lawyer over here, but don't be shy. Survive. So we're going to have a countdown. We need to have a countdown. I shouldn't count down. Oh, now let the pressure to me. Okay. All right. Ready up. All right. Ready up now. So we're going to be honoring and opening the fantastic Legal Aid Fair. Mr. Hilton, my classmate from back in the day. Ready?
Let's do it.
We're gonna do it in 5, 4, 3, 2, 1, let go. Just like that, the legal aid fair is on the way. Let's kick it right now.
All right, so
Thank you, Ms. Carter. And we also want to take note of the fact that we appreciate Mr. Hilton for attending and releasing the balloons. And just to state that Miss Nancy Anderson of blessed memory was also a tutor of the Norman Manley Law School Legal Aid Clinic and very instrumental in dealing with persons who we will be addressing in the next presentation, persons who were unfit to plead. We now invite Ms. Olivia Harris to introduce our next speaker, who is Ms. Tamika Harris. Over to you, Ms. Olivia Harris.
Thank you, Ms. Levy. Like many other children growing up in Jamaica, Ms. Harris wanted to be either a doctor or a lawyer. She decided on law. After completing law school, Ms. Harris worked at a small law office in rural Jamaica and then a medium-sized firm in the corporate area. It was then that she fell in love with the practice of law and the joy of helping others. In 2005, Ms. Harris started her own practice. Ms. Harris has over 15 years of experience in criminal law, property transactions, civil litigation, and divorce proceedings. Through her educational tenure, Ms. Harris has attained an international relations and economics degree with second-class honors upper division, as well as a Bachelor of Laws with second-class honors upper division, as well as a certificate of legal education. Currently, Ms. Harris serves as a member of the Jamaica Bar Association as a council member. She serves as a board member of the Advocates Association of Jamaica, a board member of the Legal Aid Council, and the director of Crime Stop Jamaica. Without further ado, join me in welcoming Ms. Tamika Harris.
As we would say in court, we crave your indulgence for Ms. Harris to join. I do believe she is on now. Ms. Harris, are you able to join us?
Oh, yes, I am. My sincere apologies for my background. I am technologically challenged. Please forgive me.
Okay, is it possible to close the screen a little? There's a light reflection. Thank you. Yes, that's it. Thank you. Well, Miss Olivia Harris has introduced you. So as soon as you are ready, you may proceed.
Very well. Good morning. My name is Tamika Harris, and I'm pleased to be making this presentation on behalf of the Legal Aid Council. I'm going to start by playing just a short snippet for you. I want you to listen very carefully. It's a short video. It's a short audio.
For Jamaica, some 313 mentally ill people are locked away in correctional institutions across.
Are you able to hear?
Yes, we're hearing you. Thank you.
The island, even though they're not supposed to be there. Director of Medical Services at the Department of Correctional Services, Dr. Donna Royer Powell, says there's nowhere to adequately accommodate them.
It's the judges also that are sentencing these people to our psychiatric wing, right? So we've met with the Chief Justice to tell him that we have no psychiatric wing, and it is still happening. It is still happening. There's no psychiatric wing in any of the correctional centers.
Dr. Royer Powell says they also don't have any full-time psychiatrist and only one psychiatric nurse. The report notes that the situation is bound to exacerbate mental illness rather than make those persons better. Deputy Public Defender Victor Hemmings says he's been to the area where the mentally ill are kept at the Tower Street Correctional Facility. He describes it as a dungeon.
I made it to the third floor of the Jordan Daily City. You know, I literally made it. You know what you are doing? Literally, it's part of it. It's refurbished. This is the facility that we are expecting person with mental illness to rehabilitate them and to come back as normal. It will not work.
Hemmings says he vomited more than once the first time he visited. Human rights attorney Nancy Anderson said many mentally ill persons languish in prisons for years without being tried or sentenced because they've been deemed unfit to plead. In fact, the study highlighted the case of 61-year-old Walter Blackstock, who spent 31 years trying to without trial. He was arrested in 1987 for a ganja split and deemed unfit to plead.
They send them to Tower Street or St. Catherine as unfit to plead. Let us know when he's fit. And the court doesn't set another date. Something is drastically wrong with that, and the people to blame are the judges and the Ministry of Justice.
Stand Up for Tamika is recommending the creation of a mental health care strategy, which includes the recruitment and adequate compensation of a team of mental health professionals. They're also calling for the establishment of specialized mental health courts. Executive Director of Stand Up for Tamika, Paula Galata, says the Ministry of Justice was invited to today's event, but did not attend. Camila Reynolds.
Thank you. Just wanted to know if everybody could hear that clearly. Nobody's able to answer?
Yes, we heard. Yes, you may proceed.
No, the issue of the mental health, mentally challenged persons, it's not a new issue. It's something that is plaguing our courts. It has caused several different reports to be made. Miss Nancy Anderson, who formerly now deceased, was very active in organizing and structuring a system to protect their rights. Give me a second, let me find my PowerPoint presentation for you. The presentation was done or prepared by the Legal Aid Council, and it is entitled Fitness to Plead.
Minimize this, go back into the Zoom. What you want to do? I want you to go back on Zoom so that I can use the option to share screen. So go back on Zoom. You want it? All right. See your share screen here. All right. So this top one. Share. Yeah, no in. Open system preferences. Is it Microsoft Word? Zoom. Zoom will not be able to do it. Not sure.
What I want to press this?
This I want to press the Zoom, so allow it to share.
I don't know if you want to mute in the meantime, Ms. Harris.
Please forgive me.
We're not hearing Miss Harris.
Kath Harris and Jason Edkins, the parents of teenage stabbing victim Christina Edkins, arrive at Birmingham Crown Court. They were there to attend the case management hearing for Philip Simmerlane, the man charged with their daughter's murder. The 16-year-old schoolgirl was stabbed to death earlier this year as she travelled on a double-decker bus along the city's Hagley Road. The court was told that Mr. Simmerlane remains unfit to take the stand. No plea was entered as the defendant's state of mind continues to be assessed. He is next due to appear at Birmingham Crown Court on October the 2nd.
Fitness to plead. What are the factors to be considered when a defendant is said to be unfit to plead? According to Blackstone Criminal Practice, Revised Edition, Oxford University, Press 2006, an accused may fail to plead to an indictment when arraigned on an account of being mentally incapable of doing so. Under these circumstances, the accused is said to be unfit to plead. The test has been established to determine whether somebody is fit to plead in the case of Pritchard, and that is a 1836 decision. That's long, long ago, when slavery was, I think slavery was not yet abolished. It's 1838, if my memory serves me right. And it established that the test of unfitness to plead is whether the accused will be able to comprehend the course of the proceedings so as to make a proper defense. Now, in fact, that case has been developed from, and we have passed just those mere, indication. Give me 1 second, let me find my speaking notes. So the defendant must be able to understand the charge, decide whether to plead guilty or not, and follow the course of the proceedings, instruct a lawyer, or to challenge a juror. The Legal Aid Council is mandated to provide legal assistance to members of the public who cannot afford an attorney, including persons who are mentally challenged. The council has embarked on a program to assist mentally challenged inmates at the correctional facilities. In this regard, empaneled attorneys are assigned to have their matters reviewed by the courts. Recent data revealed that there is a total of 223 mentally challenged inmates being housed at the Tower Street and the St. Catherine Adult Correctional Centers. And that approximately 45% of them are unfit to plead. Now, the issue of unfitness to plead may be raised by the defense, the prosecution, or the judge. However, where the issue of the defendant's unfitness to plead is raised, a finding in that regard is totally within the discretion of the presiding judge based on the evidence presented. The primary consideration to be made by the judge is highlighted in a very recent case, the case of Vivian Rainford, and it's a 2021 case, and it was decided by Justice Shelley Williams. In that case, the defendant was a 92-year-old man, and he used a firearm to injure his wife. The issue of his mental health status was raised by his attorney. Now, the court in that case had to do a balancing act. The court has to consider protecting the public from a person who is charged for a serious offense and who could harm society. And the court also has to protect the interest per se of a mentally ill gentleman who would not necessarily have the mental capacity to appreciate what he was doing and that he was causing harm, and also would not necessarily understand the whole criminal proceedings. So the court have to balance those two conflicting interests. So what the court did was answered some of the questions that would cause this challenge. You know, how do I balance these conflicting interests? The judge looked at the law, and the first issue that she had to consider was whether it was a judge alone hearing, that is a fitness to plea hearing, whether it should be a judge alone or whether it should be with a judge and jury. No, that issue was answered quite clearly. It was very simple. The fact that the offense itself was normally, well, should be tried pursuant to the legislation by a judge alone. The fitness to plea hearing itself was also tried by a judge alone. The judge also had to grapple with the issue of what would I rely on to make my finding? What evidence need to be led to allow me to see whether this person is fit or this person is not fit? The court also had to consider if the defendant is found unable to plead, not fit to plead, what do I do with him? And the judge in that case looked at all of the issues, and in the long run, what she did was to have him, well, he will stay with his family member, but that is after the family member comes to court and indicates that they are willing to ensure that he takes his medication and would be able to monitor him so that the likelihood of this happening again, which is him shooting or injuring anyone, is minimized. Now, the standard and burden of proof, the court also looked at, and the standard of burden of proof is very similar to what we know. When the prosecution is alleging the standard and the burden of the standard is beyond a reasonable doubt. When the defense is relying on it, then the standard is on a balance of probabilities. The issue as to if the judge herself raised the issue and said, you know, I want to do a fitness to plea hearing, the court did not have an answer as to what should really be the standard of proof. So if the issue in relation to the fitness to plea is raised by the prosecution, the same standard always for the prosecution beyond a reasonable doubt. If the issue in relation to the fitness to plea is raised by the defense, it's a balance of probabilities. If it is the judge who raises it, then that there's no answer as to what really should be. The case law has not determined what should be the standard yet. I said yet because perhaps the law will develop to tell us what the standard would be. And in relation to the evidence that should be led in a fitness to plea hearing, the court relied on Section 25(5) of the Criminal Justice Admin Act, which speaks to a court or jury, as the case may require, shall not arrive at a verdict on the issue of the fitness of a defendant except on the written or oral evidence of 2 or more duly qualified medical practitioners, at least one of whom is an approved medical practitioner. So Let me say that again. So what we know of is so far is that if it is that the court is going to say, what do I rely on? I said the court had 3 questions. Remember the 3 questions. So the first question is about the burden, what is to the burden and standard, and it is basically what we already know. In relation to what the court is to rely on, the court is to rely on the court is to rely on the 2 psychiatrists, 2. And one of the psychiatrists must be an approved psychiatrist. So the next issue for the court now is, if I find this gentleman unfit to plead, what do I do with him? No, in this particular case, the court did find that he was unfit to plead. Both the evidence came from 2 psychiatrists, Dr. Clayton Sewell, and it also came from Dr. Mindy Fitzhenley. Both came to the same conclusion that he was unfit to plead. And I'm going to read it a little so that you can understand, why the court came to that decision. When the doctors gave evidence, they said that Vivian has reported history of unusual behavior for over 5 years, that he was withdrawn, irritable, paranoid, and he was having hallucinations. The court found, based on the evidence from the experts, that medication could help, and once he's compliant, that could assist. Based on Vivian Rainford's and his family report, he appears to have been acting under the influence of an abnormality of his mind, and he was deluded, and that he thought persons were threatening him. He was also hearing and seeing things. He understood the incident as being as a result of threats. So he reacted the way he did because he thought he was being threatened. He currently meets the criteria according to the experts, and the judge accepted that he had a major neurocognitive disorder with psychotic features. That was from one of the experts. They also considered whether he understood the plea, whether he understood that his rights were, whether he could follow the court proceedings, and whether he comprehended the evidence given against him, and also whether he could instruct his legal advisors and understood the advice that they were giving him. So all of that is basically what the expert would tell the court, so that the court can appreciate or come to a conclusion whether the person is fit to plead or not. No, it's all if whether the person understands the proceedings, not necessarily. We have to be careful, because sometimes, based on the education standards of persons in Jamaica, they might not necessarily understand the proceedings. So just merely not understanding the proceedings is not all, because when a person is mentally ill, no matter how much simple language we use, no matter if the lawyer speaking patois, no matter if the lawyer tell the mentally ill person the same thing 3 times, 4 times, they will not understand. While somebody who doesn't understand because, lack of exposure or lack of education, once the lawyer explains in plain, simple language and using Jamaican language, patois, and probably explain it more than once, the persons would be able to appreciate the occasion, appreciate the court proceedings, understand what is happening, give instructions. But when somebody is suffering from a mental illness and cannot plead, no matter how no matter how often it is explained, they will not appreciate and will not be aware of their surroundings and not be able to give instructions, appreciate what is happening in court. And for that reason, the court will say this person is not fit to plead. So there's a distinction between just not understanding it or will not be able to understand it. Dr. Mindy came to the same conclusion that he has a chronic mental illness. So both doctors in that case came to the same conclusion, he was not fit to plead. Now the hard question now then for the court is, what do we do? Because we know that as we've heard in the clip that I played earlier, there is really no proper facilities at our prison for persons who are mentally challenged. And they are often just placed in custody and are lost or hurt. And so what the judge do then? How she manage all of these conflicting interests? Because yes, there is no proper facilities, but at the same time, I need to protect society from him. Because here is this man with a firearm shooting his own wife. So what do I do? How do I balance this? So that's all of it is balancing the different interests. So the court in this case, and this is a very instructive case. The court made a guardianship order. And this is where the court appoints someone to be the guardian of the defendant, the guardian that would have to indicate to the court that he is willing to become the guardian of the defendant. So the duties of the guardian would include requiring the defendant to reside at a particular location, requiring the defendant to attend at places and time so specified for the purpose of treatment, occupation, education, or training. Give access to the defendant at any time, any place the defendant is residing, to any approved medical practitioner, probation and aftercare officer, or other person so specified. So in attempting to come to a decision, the court looked at a social inquiry report, and in that report, they found the persons found him to be generally friendly and quiet. So in all of the circumstances, and in this case, the wife who was injured was asking for leniency for him. So the court took into consideration the age of the defendant, the offenses he was charged with, whether the defendant had any support from either his family, friends, or neighbors, and whether there's any community-based mental health facilities in or near the community the defendant resided in. And after reviewing all of that, the court found that the most suitable option for the defendant was a guardianship order. And Mr. Errol Rainford, that is his son, volunteered to become his guardian. So that is how that matter was dealt with. So, so that case beautifully laid out what the court's considerations were, what the court's options were, and I must admit that the court took into consideration the conditions of our prisons, and it cannot be denied that it is not therapeutic. That's my word. So the primary characteristics . Whether the hearing should be judge or jury or by judge alone, and that is answered beautifully by the Criminal Justice Admin Act. And the amendment to the Criminal Justice Admin Act, particularly section 25A4, details that where a defendant is said to be unfit to plead and is being tried or said to be tried before a court other than a court comprising of a judge and a jury, the court shall try the issue and render a verdict. I already looked at what the burden of proof would be. And Please forgive me. So I'm going to go through this slide very quickly because I think I've discussed this already when we looked at the Vivian Rainford case. So according to section 25.5, the Criminal Justice Admin Act, the judge must not make a determination that the defendant is unfit to plead except on written or oral evidence of 2 or more duly qualified medical practitioners, at least one of whom must be an approved medical practitioner. The information that is solicited by the doctor touches and concerns the following: whether the accused is fit to plead, whether the accused will be able to understand the nature of the charge, whether the accused would be able to understand the difference between a plea of guilt and not guilty, whether the accused would be able to properly instruct counsel. After the evidence is taken, the judge sums up the evidence and makes finding of fact. Where the court finds that the defendant is fit to be tried, then the trial will commence in a normal manner with the information or indictment being put to the accused. What are the options available to the court if the defendant is found unfit to plead? Let us look at them again. Where the verdict on trial on issue of fitness is that the defendant is unfit and any plea that he has made shall be set aside. Section 25(c)(2) of the Criminal Justice Act, Administration Act provides that where there have been findings that the defendant is unfit to plead, the court may make an order in relation to the following: order that the defendant be remanded in custody at the court's pleasure. Order that the defendant be admitted to a psychiatric facility named in an order. Make a supervision and treatment order in respect to the defendant, or make a guardianship order in respect to the defendant. And we saw that in Vivian Rainford, the court made a guardianship order. Please note that the verdict of an unfit to stand the trial shall not prevent the defendant from being tried subsequently if he becomes fit. So when the person is at the court's pleasure in custody, then there is an issue as to when is he to be brought back before the court so that another hearing can be conducted to see whether it's fit. And that is how we have seen that we have failed as a country. We have failed the mentally ill. There have been many cases where they have not been brought before the court in a timely manner or not brought before the court at all. And I'm going to just briefly go through the case of George Williams. And that is a case where this gentleman spent about 4 decades in custody and not having the opportunity to have a trial at all. Now, in this case, the Queen and George Williams is a 2020 case. It is reported on the Jamaica Supreme Court Criminal 8. It was decided by Stephanie Jackson Hazley. In that case, the accused person was a 75-year-old gentleman, Mr. George Williams, and he appeared before the court on the 17th of June, 2020, and he has spent a greater part of his life at the St. Catherine District Prison. He has spent approximately 50 years in prison. He was first incarcerated in 1970. He was charged for murder and he was diagnosed as being schizophrenic and unfit to plead. He was detained at the Governor's General pleasure. Now, from 1970 to 2020, he has been in custody, and he has never, ever, ever been tried. He didn't go to a trial at all. And what has happened is that he was a patient at Bellevue before he committed the offense, or before it allegedly. And at the time, he was an outpatient. He was arrested and charged for murder and was taken before the court in St. Catherine on a few occasions. He was assessed as being unfit. However, he has never been taken back to the court until he first appeared before the judge June 17, 2020. The matter came to the attention of the court when counsel, Mr. Buchanan, made an application for him to be brought before the court. Among the orders sought were a writ to be issued to the superintendent of the St. Catherine District Prison, and he sought for Mr. George Williams to be released and for the case to be dismissed for want of prosecution. In his affidavit, Mr. George Williams swears that he has been imprisoned without trial since around July 21st, 1970, and that he was first indicted for a criminal offense on the 29th of November, 1970. Mr. Williams asserts that he has seen multiple persons convicted for murder serve their time and return to society, whilst he sits in prison awaiting trial. He says that he has not received constant psychiatric treatment during his incarceration. Further, that he was a patient at Bellevue from 1965, and that Miss Velma Hilton was the Crown Counsel, that he said that she, as far as he is aware, she advised the court that he was wrongly in prison. I don't know how true that part is. Ms. Hilton is not here to defend herself or to say whether it is so. But she advised, according to my Crown Counsel, actually advised the court that he was wrongly in custody at St. Catherine Prison and that he should have been brought to Bellevue Hospital. He asserts that he has been found fit to plea on more than one occasion. And as recent as February 22, the 2020, by Dr. Barnes, his life for the past 50 years has been a living hell. He has witnessed in more than 49 years in custody all types of death row prisoners being released whilst he hopes for his day in court. The court heard from Dr. May Hu, R.O., and Dr. Jeffrey Walcott, and the court also had a social inquiry report prepared, and they found that he was alert, but his insights and reality were still poor. His memory appeared to be impaired, and he only remembers selective areas of his life. He still suffers from the disorder of schizophrenia, and his mental illness is still chronic. He could not answer any events relating to the events and being charged, and therefore he remained unfit to plead. So after spending so many years in custody in what the person would call the psychiatric wing, and we were informed that there's no such wing, he is still unfit to plead. So what was the real purpose of him being in custody, not having a trial, still unfit to plead, and just spending days. So the court, again, based on the social inquiry report, based on the reports from the two doctors, the court tried to find the best way to have the issues dealt with, and they imposed a guardianship order. In this matter, the family members have demonstrated an interest in the welfare of the subject, and this is supported by what the probation officer said. And what they have now done is to, the doctors have been saying that he's a low risk, meaning, it's not like that he's going to cause any harm again, and has shown no violence over the last couple of years. It is hoped that he will remain so, and the family will play an integral role in maintaining this. He's schizophrenic, and so if he doesn't get the required care, there is a possibility that he will relapse. So again, the court came to the conclusion that prison was not the right environment, and with love and affection and care from your family, if you are mentally ill, then perhaps you should return to your family. He was encouraged to take advantage of the available social services, such as a community mental health clinic and the probation department, who had expressed an intention to assist him with his follow-up. Mr. Williams also has a role to play according to the court. In the process, he must take his medication and work with family members, medical practitioners, and probation officers. So the court made some recommendations, and Mr. Williams had the responsibility to ensure that he abides by the instructions of the court and the medical officers and his family and friends. So there is also an issue in relation to how we deal with our mentally ill, that even in the issue of sentencing, how is the court to deal with somebody who has demonstrated that they are not, or there is some slight evidence that their mental status could be an issue. And even though this doesn't speak to the whole fitness to plea hearing itself, but I thought that it would be interesting or important for me to mention the case of Ian Johnson, and that is a 2015 case. And that case was argued at the Court of Appeal level, and it is in relation to sentencing. In that case, the gentleman was sentenced. The court was given some indication that he has some mental health issues, and instead of ordering for a psychiatric report to be done to assist in the sentencing process, the judge instead ordered that whilst he is in custody and serving his sentence, he is to be evaluated. The Court of Appeal is saying, no, the evaluation should come before you sentence him, so that it could guide you in relation to what would be the appropriate sentence for this offender. Let me tell you more about the case. It's Ian Johnson versus the Queen, and it was decided by Justice Morrison, the Honorable Mr. Justice Morrison, the Honorable Miss Justice Phillips, and the Honorable Miss Justice Lawrence Beswick, who was acting at the time. The case was argued by the famous Mr. Robert Fletcher, and who acted for the applicant, and Miss Tracy Johnson, who's now a parish court judge for the Crown. It was from 2015. The judgment was written by Justice Morrison, the Honorable Justice Morrison. At the conclusion of the hearing of the application for leave, the court made the following order. The application for leave to appeal is granted. The hearing of the application is treated as a hearing of the appeal, which is allowed, and the sentence of 20 years imprisonment imposed by Justice Morrison, it's two different Morrison, so be careful, is set aside, and the matter is remitted to the Supreme Court for resentencing. So that was the outcome of the matter. The matter was sentenced for resentencing because the judge did not take into consideration that a psychiatric evaluation should have been done to assist the sentencing process. So there was the resentencing exercise is to be informed by evidence of a comprehensive psychiatric evaluation of the applicant. The following information as to the applicant's mental state was then conveyed to the court by counsel for the prosecution, and let me read it. My lord, I will indicate for completeness that the basis on which the prosecution has agreed to accept the plea to the lesser offense, which rests in a psychiatric report done on the applicant by Dr. Charmaine Singh, which reveals that the applicant, in her words, suffers from schizophrenia, and that at present is at some time of the examination was not found to have evidence of psychosis, and of such he was deemed fit to plead today and is to continue a course of treatment outlined in his assessment. So the court accepted a lesser plea based on the fact that he wouldn't have had the mental element to commit the offense. Right, so that's good. The prosecution accepted the lesser offense. The learned judge immediately comments was that he was not persuaded that the gentleman, that Mr. Johnson was schizophrenic. However, at the request of counsel for the applicant, a social inquiry was ordered and the matter was adjourned for sentencing. On that day, the report presented to the court revealed that the applicant had a number of previous convictions and that he had exhibited a pattern of persistent antisocial behavior in the past. The probation officer who prepared the report observed that despite the fact that when interviewed, the applicant maintained he was mentally and physically well, his disposition and interactions, however, caused questions as to the stability of his mental health. So even the probation officer was saying, something right here. So the probation officer further opined that in the circumstances, confinement seems necessary to provide the applicant with appropriate mental health supervision if required, and to protect the family as well as the society from his consistently unacceptable tendencies. After a plea in mitigation made by the applicant's counsel on his behalf, the learned judge had sentenced him to 20 years imprisonment. The learned judge made a recommendation that while in prison, so this is the part I want you to pay attention to. It is while in prison, the applicant should be given a schizophrenic evaluation and possible psychiatric evaluation. So he's sentencing him and saying, while he's serving this time, he should get this evaluation. The applicant's single ground of appeal was that the sentence of the court was manifestly excessive. And in order to determine the appropriate sentence for the applicant, more information of a medical nature ought to have been obtained by the court. And this is in light of the questions raised by both counsel for the prosecution and outlining the facts, and by the probation officer in the social inquiry report as to the applicant's mental state. So the mental state was an issue. It was the prosecution and the defense accepted that there was some mental issue. The probation officer also accepted that, there was some mental issue. So what Mr. Fletcher was arguing that, well, if that issue came to the court's attention, the court ought to have done more in relation to the sentencing of the convicted person. In support of his submission, Mr. Fletcher relied on several case law, and the Court of Appeal agreed with him. And it says, notwithstanding the learned judge's own apparent skepticism as regards the applicant's mental condition, he nevertheless thought it prudent on the basis of the material before him to make a recommendation that the applicant be given a psychiatric evaluation while serving his sentence. In this case, the situation was compounded by the material very properly provided to us by counsel for the prosecution during the hearing of the application, addressing the issue of the applicant's fitness to plea before the matter came on for trial. That material clearly demonstrates that up to the week before the trial date, the applicant had been diagnosed with schizophrenia. In all the circumstances, we are going to conclude that by not ordering a psychiatric evaluation of the applicant before passing on sentence, the learned judge have deprived himself of critical information relevant to the sentencing process. So that is Ian Johnson versus the Queen. So what we have here is a situation where the mental health issue can affect not just the verdict, it affects the verdict, it affects whether you are able to appreciate the trial process, that is whether you're fit to plea or not, and it also affects your sentencing. So we can't ignore it. It is something that is very important, and it goes to the issue is you have to sentence according to the offense, but the sentence must be fitting the particular offender. So the dangers associated with implementation of the options available to the court. I'm going to look at them. I think we looked at it already, but we're going to look at it again. While being held at the court's pleasure, the defendant faces the risk of being in prison for an extended period of time for a fairly minor offense. And this reality is faced by many of our mentally challenged inmates. And we can bring, even though George Williams spent several years in custody, not for a minor offense, but we can also, I think it's Noel. All right, I don't remember now, but I think it's Noel's son. Well, I'll get that information. There's this gentleman spent about 50 years in custody for a very minor offense. Very, very minor offense. And give me a second. Let me get that information. Yes, thank you very much. It just came to my mind when I was reading this, that there is indeed a case of a gentleman who died in custody, and he was in custody for an extremely long time. He was in custody for extremely minor offense. I want to give you the exact information. I don't want to mislead you. So give me some few, we'll go back to that when I get it. But that is the risk. There's also the option of remanding the defendant at the court's pleasure at a psychiatric facility. And that is a problem because we only really know of Bellevue. And as I said before, there is no psychiatric wing at any of our institutions or penal institutions. The court has a range of options in determining the fate of one who has been said to be unfit to plead. We looked at Vivian Rainford. The court grant guardianship order. This option could be exercised more by the courts once the medical evidence supports it, if family members of the mentally challenged are willing to provide care and control of these persons. In the circumstances of the mentally challenged inmates are to change, efforts must be made to increase the number of psychiatric facilities operating in the island. This must be complemented by national campaigns aimed at removing the stigma attached to the mentally ill person. Now, that is the end of the presentation. If there's any questions, please feel free to ask me. But while we're asking the questions, I will get the information about the Noel something case.
So thank you for that, Ms. Harris. And I believe it was a very thorough presentation. We appreciate you coming and participating in our legal aid fair. We acknowledge that it was, I think you had to step in with some short notice. And so we really appreciate you filling that gap. The presentation, we commend your reference to at least two of our two persons who would have been associated with the law school. Mr. Robert Fletcher, he did in fact give us a presentation earlier this week, and of course, Miss Nancy Anderson of blessed memory. Thank you so much. At this moment, we take the opportunity to invite Miss Joan. Well, first of all, we do have, let me find out if we do have questions. We do have one. What would be the difference between supervision order and the order where the accused is required to undergo treatment at a hospital or mental institute?
Supervision order? I'm not sure there's a supervision order, there's a guardianship order.
Okay, maybe that is the reference.
All right, so the guardianship order is more when the person is in need of extra help. So you need a guardian. If the court feels that what was it, the next one? Guardianship, I'm gonna say guardianship.
And the mental facility. For example, Bellevue. Or any other mental facility that I do understand that you indicated that we don't have in prison, we don't have a facility to hold such persons. I gather the question is trying to extract what would be the difference between being housed where someone is the guardian over this person, as opposed to being placed in such a facility.
All right, so you'll be placed in a facility once the facility is available and able to take the person. And particularly in a situation where there is not a person or a family member who will be able to step up and say, I will be guardian and I will take control of the individual. So you'll be placed in a facility, or the court will consider placing someone in a facility if there's no family member that comes aboard to say, hey, I'm available, I can take care of my family member. And once there's a facility that is there and exists, and who is willing to take the person, because sometimes the facilities like Bellevue don't want to take an individual charged for a very serious offense because they fear for the staff life and also for other inmates there, or in other patients there, sorry, say it's an inmate thing, other patients. Mm-hmm.
Okay, thank you for that. We now invite Ms. Joan Lawler to give our vote of thanks to Ms. Harris.
Ladies and gentlemen, good afternoon. Ms. Harris, thank you so very much for a detailed presentation, full of examples, easily understood, very thorough. You kept us interested by being as clear as you could. And on behalf of the Legal Aid Council and the members listening to this fair, I'd like to say thank you very much. We are very pleased with the presentation. And just to say, your reputation preceded you and you lived up to it. Thank you very much.
Thank you, Ms. Lawler. Ms. Harris.
Thank you. I think Ms. Lawler has been extremely kind. But
well, we do acknowledge that you were in a very public case recently, and which I suppose is, what Ms. Lawler referenced just now. And we appreciate your service to the general public in these matters. And we are happy to have someone who can champion the cause, certainly as our greatest, I would say one of our greatest champions, Miss Anderson is no longer with us.
Yes.
We want to thank you again for presenting, and we invite persons to come on down to the Legal Aid Clinic at 18 Gibraltar Hall. As mentioned before, we do have several agencies here on site who are available to answer any questions that you may have. This evening at 2:30, we will have Miss Tamisha Powell, who will be speaking on silent pleas, domestic violence, bad touch, good touch, don't touch, looking at the Child Care and Protection Act. That will be our next broadcast at 2:30. For further information, you may contact us at nmls.edu.jm or email us at nmls.lac@umona.jm. You may also contact us on WhatsApp at 876-561-9803. I'm Janet Levy. I thank you to all the audience and all students who are here. Thank you for attending this session.
Thank you for having me.
Thank you.